Um, Again, welcome to the April program of the League of Women Voters of the Northwoods. I'm Pam Taylor. I am the president of our local chapter in the Northwoods and glad to present this program to you. I'll go over some of the overall rules first. Everyone will be muted during the presentation. We have an expert guest who is going to give us our presentation. All questions that you have, please put into the chat. And at the end of the presentation, we will respond to those questions. And also there will be a time to ask questions live in which either myself or Louise Schatz will call on people. So if you have a question during that time, either physically raise your hand or raise your little blue hand on your Zoom hand, and we will try and get all the questions in. Anytime you have questions for the League of Women Voters or comments about any of our programs, you can always send them to us via email at information@lwvnow.org. And we will be glad to respond to those. So welcome. We are really excited to have Dunphy here with us today. He was the Lincoln County District Attorney from 2004 to 2016 and is a member of the League of Women Voters. He was born in Wisconsin, was a Marine, went to the University of Wisconsin at Stevens Point, was a youth counselor at the Ethan Allen School, and went to Marquette University Law School. So we're thrilled to have him today to talk to us about the Second Amendment, the original intent, and Supreme Court interpretations, as well as the current status of the ERA. Now, this is an informational and educational meeting, and that is not meant for argumentation or soapboxing or anything of that nature. We intend to learn a lot, and we welcome you, Don. Thank you. Don, please unmute yourself.
Okay, don't know how that happened, but can you hear me now? Okay, thank you, Pam, and thank you to the League of Women Voters for giving me the opportunity to make this presentation. I'm hoping that everybody can hear me. If there's a problem, let Pam know, and we'll try to make adjustments. Okay, there are two topics on the agenda for today. One is the Second Amendment, and the other one is the Equal Rights Amendment and what the status is as of right now. Just to let you know up front, whenever you're discussing constitutional issues, there are a lot of gray areas. And even after the constitutional provision has been interpreted by the court, the Supreme Court and all the lower courts are very resistive to setting what they call bright lines. So we never get a complete answer to anything. There's always room for interpretation in almost all cases. So going to the first topic, which is the Second Amendment, a very short amendment. All it says is a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. And this was part of the Bill of Rights, which was passed before the Constitution had been fully ratified. I think there were still two states that had to ratify. And the reason it was included with the other amendments in the Bill of Rights is there was a great deal of fear among the founders about the power of a central state, and particularly the power of a standing army to become an instrument of repression. So the amendment itself was authored principally by James Madison, and it was done in response to a passage in the body of the Constitution that gave Congress the right to arm and call up state militias. And in the to mitigate some of that power, the amendment was passed giving or leaving intact the rights of the individual states to call up the militia whenever they wanted to or needed to. And there are a number of reasons why the states wanted that authority. One was, I believe I've already mentioned, they thought that the militia would be a counter to the power of a standing national army. They also felt that militias could nullify oppressive political overreach by the central government. At that time, there was no formal police organization in the states. There were sheriffs who could call up a posse. There were in the cities, there were things called the Watch, which were voluntary organizations. But if, for instance, the excise agent in the port of Charleston wanted to overreach his authority, there was very little that the states could do about it other than calling up the militia and forcing the agent's hand. So the final one, and this is probably the most controversial, but at least in the South, there was a thought that the state militias were necessary to put down potential slave revolts. And a lot of the Southern representatives to the Constitutional Convention were very vocal about that. And in fact, there is a lot of belief that James Madison wrote the amendment the way he did, tying the individual right or tying the right to bear arms to the militia function, because in the South at that time, free blacks were not allowed to enlist in the militia. Okay, and I guess most of the controversy surrounding the Second Amendment arises out of the tension of two trains of thought about how the amendment should be interpreted. There is one train of thought that it is a collective right for the people as a body or the states as a body to use. And the other is that it is an individual right to keep and bear arms that existed prior to the Constitution. And the phrase a well-regulated militia being necessary to the security of a free state was added to give some purpose or an additional purpose to the idea that all citizens had the right to keep and bear arms. And prior to the 21st century, all courts that had considered the question were unanimous that the right was a collective right. So as far as the federal courts were concerned, prior to 2001, the right was a collective right. That changed when the United States Circuit Court of Appeals for the Fifth Circuit decided United States versus Cameron in 2001. And for the first time, that circuit recognized that there was an individual right to bear arms. That was followed 7 years later by the first pronouncement on the subject by the United States Supreme Court in District of Columbia versus Heller. And if you want the citation, I can give it to you, but I think I'll reserve that for questions. The idea here, or the controversy in Heller, was that Mr. Heller owned a pistol that he kept in his home. And under a city ordinance in the District of Columbia in Washington, D.C., pistols that were kept in the home had to be registered, number one, and number two, they had to either be equipped with a trigger lock or disassembled. And Justice Alito, who wrote the Heller decision, decided that that would effectively cancel out Mr. Heller's right to have a weapon of that type in his home for purposes of self-defense. And for the first time, the Supreme Court found that the right to keep and bear arms was in fact an individual right. And that still left a question unanswered about how the individual states might be able to regulate firearms, because DC is a federal enclave. It's carved out of the surrounding states of Maryland and Virginia, and is under the exclusive authority of the federal government. And the question about it was, did the Fifth Amendment in the federal Constitution apply to the individual states? And that question was answered 2 years later in the Illinois case, or in the Seventh Circuit case of McDonald versus Chicago. And there, Mr. McDonald had wanted to possess a firearm for self-defense, and there was a city of Chicago ordinance that required that all such weapons be licensed. And the Supreme Court decided that no, by operation of the 14th Amendment, the Second Amendment was effective against the states as well as the federal government. Okay, now, neither of the Supreme Court decisions makes the right to keep and bear arms a right to keep and bear any arms that you want to. And that was clear from Justice Scalia's opinion in Heller. He said that that the right to keep and bear arms was a limited one, that it was perfectly permissible to regulate or forbid felons and mentally ill people and other regulations of the sort to have firearms. He indicated that the government may require registration and licensing. That would not be forbidden. And also, the right to keep and bear arms does not authorize ownership of all types of firearms, only those usually kept for legal purposes, for example, self-defense. Okay, and that's the end of my Second Amendment presentation. Now, going to the second topic, the Equal Rights Amendment. That amendment has not been put into effect yet, but it is a little bit more lengthy than the Second Amendment. What it says is there's 3 sections to it. Equity of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. The Congress shall have the power to enforce by appropriate legislation the provisions of this article, meaning the Equal Rights Amendment, and this amendment shall take effect 2 years after the date of publication. Now, the Equal Rights Amendment has a lengthy history going back a century. It was first introduced in Congress in 1923. It was authored by Alice Paul and Crystal Eastman of what was called then the National Women's Party. And it did not pass both houses. Actually, I don't think it got a floor vote in either house in 1923. And it was regularly reintroduced every session thereafter until in 1971, it was reintroduced for a final time by a Representative Martha Griffins. And that time it passed the House in 1971. It went to the Senate in the spring of 1972, and the Senate passed it also. Now, there's more than one part to ratifying a statute. The Article 5 of the Constitution, which sets out the method for amending the Constitution, requires 2 things. First, 3/4 of both houses of Congress must pass it. And then it has to be, 2/3 of each house has to pass it. And then it is released to the states for ratification, and 3/4 of the states have to ratify it before it becomes effective. That being the case, in 1972, the ratification process by the states began. And in the first year, 30 states ratified the ERA. And the ratification of the amendment would require, and still requires, only 38 states. Slowly, 5 other states gradually the gradually ratified the amendment over increasing opposition, principally from a person named Phyllis Schlafly. And she was pretty much the go-to person if you didn't like the Equal Rights Amendment. And she would form parties to go to state legislatures that were considering ratification, and it would bring things like apple pies to the legislators to symbolize the fact that a woman's place is in the kitchen rather than elsewhere. And eventually, 1979 came around, and there were still only 35 states that have ratified the amendment. Now, the significance of 1979 was in the resolution, not in the proposed amendment, but in the resolution, in the first paragraph of the resolution that passed Congress, there was a seven-year time limit for ratification of the amendment, and that expired in 1979. It was extended until 1982, but no additional states ratified it prior to 1982. So the time limit expired for a second time, and most people considered the Equal Rights Amendment a dead letter. But there were certain proponents that were not ready to give up on it. And the reason is Article 5, which of the Constitution, which sets out the process for ratification, has nothing in it that requires a deadline. And the deadline itself is kind of a new idea, new in the sense that it was only in the 20th century that, and I believe in 1920, that amendments first started having deadlines for ratification. That was something that Congress came up with. And the proponents of the ERA pointed out that since the deadline was not in the amendment itself, and the amendment was the thing that the states had ratified, the deadline did not bind the hands of the states. And as soon as 38 states had enacted it, it should become effective. And the push continued for ratification until, let's see, I believe it was April. Well, I would note that many constitutional scholars, including Lawrence Tribe, agree with the proponents of the ERA that the deadline does not now nullify the ratification. So there is a lot of good legal scholarship that supports it. Now, of course, there's others that think that the deadline nullified the amendment. Okay. Oh, here we go. Okay, the state that last ratified, the 38th state, the last one required, was Virginia, and it ratified the ERA in 2020, 2 years ago. 2 years ago in March. And now the proponents are arguing that, in fact, the ERA has been legally ratified and is, in fact, an operative part of the Constitution because more than 2 years have elapsed since it was enacted, which, if you remember, that was the third section of the ERA when it passed the Congress in 1972. And a lot of people have been dismissive of the idea that an amendment that takes so long to go through the process can still be ratified. But in fact, the record holder for length of time to ratify is the last one that we had, which was the 27th Amendment. It was first proposed by James Madison in 1989, and it wasn't ratified until 1992. So it took over 200 years to ratify. So in that context, the ERA is kind of a recent proposal. Okay, there is another question that's kind of a sticking point with people that don't believe the ERA has been ratified, and that is that after they ratified it, six of the ratifying states rescinded their ratification. But again, the Article 5 of the Constitution gives no authority to a state to rescind its ratification once it's made. And again, there's a lot of constitutional scholars that agree with the proponents that because the article is silent on the subject, states cannot rescind their enactments. And of course, there's counter arguments to that, but that's where the matter stands now. I would note that a couple of representatives, Jackie Spears for one, she's a Democratic representative from, I believe, California. Yes, and also Carolyn Maloney from New York, again, a Democratic representative, along with 154 co-sponsors, have introduced a resolution affirming that the ERA is validly ratified and is now in effect. And we'll have to see where that goes. It has not passed either house yet, as far as I've been able to learn. Keep your fingers crossed. So anyway, people also question why the ERA is necessary. And I guess they point to other sections of the Constitution, like, well, the provision for equal rights under the law, and say it really isn't necessary. We don't need it. Even if it is ratified, it'll just be symbolic. But there's a couple of things about that people don't get. One is that Congress can pass laws, for example, pay equity between men and women, require pay equity. And then the next Congress 2 years later can come along and repeal it. Constitutional amendments can also be repealed, but only one has ever been repealed. and it has to go through the same process of passing through both houses of the Congress with a 2/3 vote, and also be ratified by 3/4 of the states. So unlikely that if you're protected by an amendment, it'll ever be repealed. And the other thing about it is, when you're suing on the basis of discrimination on the basis of gender, right now, without the ERA, the level of judicial scrutiny that the statute must meet is an intermediate level. And I apologize, I'm not sure what that involves, but the other thing is that if the ERA is ratified, that would elevate the right to not be discriminated against on the basis of sex to the dignity of a fundamental right. And when a fundamental right, when the allegation is that a fundamental right has been violated, the level of scrutiny is something called strict scrutiny. So it more or less puts the burden on the people that are defending the statute to prove beyond a reasonable doubt that the statute itself is constitutional. And that is a very high burden to meet, and a very good reason to have an amendment of this sort in force and effect. So that's my presentation. If there are questions, I can certainly do my best to answer them. Okay. Dorothy.
Don, yeah, did you see that? Okay.
Yes, I did. Yes, I did. Well, like I said, when you're talking about the Constitution, there are always gray areas. And a strict constructionist, as some justices like to style themselves, would look at Article 5 and say, well, it's already in force and effect. Why? Because it has met all of the requirements set out in Article 5. However, there are courts and that have said in the past that if you've got a deadline that ran, then it has to go to Congress. There has to be a resolution that passes both houses. And at that point, it becomes a valid constitutional amendment. Where we are at this point in time is there's been a resolution introduced in Congress, and no matter how this turns out, there will be lawsuits because if the resolution doesn't pass, there are going to be people that say, no, you can't do that because we've already met all the requirements for ratification. Keep your opinions to yourself, Supreme Court. That's what the Constitution says. Of course, the Supreme Court can always reverse itself. But anyway, the other thing is that if the resolution passes, there are people prepared to sue over the fact that the deadline ran, and again, courts can't revive it, and Congress can't revive it after the deadline has run. So I hope that answered your question. If not, you can contact me on my email, and I'll try to do a better job. And that's dondunphy@hotmail.com. Oh, yes. Susan, Yeah, Phyllis Schlafly and the people that kind of gathered around her were concerned about a number of issues that probably seem a little bit archaic to us now. They were concerned about the status of housewives because, you know, back then, before women were in the workforce, or not very many women were in the workforce, the typical housewife, her entire economic well-being was bound up in the breadwinner's hands, the husband's hands. And there was some thought that with an ERA, or with an Equal Rights Amendment, husbands would no longer be required to take care of their wife as a dependent. Also, there were women that worked in factories that were given, their work in that environment was facilitated by requiring less of them, less heavy weights, less speed on the assembly line, things like that. And it was thought by women that worked in that kind of environment that with an Equal Rights Amendment, those considerations would go away, and they would be required to lift the same weights, work at the same pace as men. And the other one was there was a fear that it would erode women's rights when it came to divorce, especially in custody hearings, that men would make it more difficult for women to attain custody of their children in divorce. So those are the three main things that I've uncovered in my research.
Do you see that question? It's why are there people who oppose this amendment currently?
Okay. I think the main reason, and certainly it's not the only reason, because people can think of a reason to resist change no matter what. But I think the main reason is there's some thought on the right, and I hate to put it that way, but there's some thought on the right that it would make it more difficult to ban abortion, because their feeling is that an Equal Rights Amendment would more or less guarantee that women would be able to have abortions. I think it's a stretch. I really do. But that's the main reason that I've heard about why the ERA is so adamantly opposed by the right.
Louise, do you want to ask the next question?
Okay, I was hesitating because I knew Don was, he was seeing the chat as well. Is a strict constructionist different from an originalist when it comes to interpretation? Or is that something of a moving target depending on what the opposition thinks would work best to defeat it?
Okay, I think I can answer that. I don't think there's any difference between original intent and strict construction. There have been 27 amendments to the Constitution. So when you talk about original intent, you're not only talking about the original intent of the founders, but also the intent of the proponents of the various amendments. So that in itself requires some ability to hold two different thoughts in your mind at the same time, because attitudes toward basic rights, civil rights have shifted over time. As far as when people say they're strict constructionists, I think it is kind of a moving target. At least it seems to be that way to me. It seems as if, for instance, when we're talking about the Second Amendment, for over 200 years, our federal courts were telling us that that was a collective right. And Justice Alito decided that it wasn't, that it was an individual right. And he was a strict constructionist, a big proponent of original intent. And there were a lot of constitutional scholars that disagree with him at the time, but of course, he was writing for the majority of the Supreme Court, so he had the last word on the subject.
The next question was my question, and it was about the ERA. Would passage of the ERA prevent states from enacting legislation to limit the rights of LGBTQ people in their state?
I would hope that it would, but again, that's a gray area because there are plenty of people that would argue that there are only two genders, and that is male and female. And the LGBT community, when they advocate for themselves, say that they identify with one or the other, even if they might be biologically in the other classification. So not everybody agrees with them, let's put it that way. And there probably would be a period of time where that would all have to be sorted out in the courts. You know, if you were a trans person and, for example, and you sued because you thought your employer either discharged you or a prospective employer didn't hire you for that reason, the courts would have to sort out whether the phrasing of the ERA prohibits discrimination on the basis of biological gender or the gender that you identify as. I guess my thought on it is equal is equal, but you know, I certainly don't have the last word on that.
Mm-hmm. A little bit more to that question. This goes back to the Second Amendment. You mentioned that the laws all have some vagueness about them and their interpretation. What that said to me right away was, man, does it matter who's on the Supreme Court?
Oh yes.
And I find that a pretty scary idea.
Yes, yes. No, you know, just we say that the Constitution is a supreme law of the land, but it was meant only as a framework that has to be fleshed out by laws made by Congress and the state legislatures and decisions made by the court. So, and it was deliberately done that way so that there would be some flexibility in, you know, in the Constitution so it could meet changing conditions.
We have
Sometimes
another
that's not-
question.
Go ahead.
Yeah, that's hard. Another question from Dorothy Sky. Which gun restrictions, if any, that don't violate the current interpretation of the Second Amendment have been readily adopted? And have they been shown to reduce gun deaths?
It's very difficult to determine if any regulation or no regulations has an effect on gun deaths, because the what is it, the Center for Disease Control, or it's the federal agency that studies health risks to the nation. They would typically be the agency you would go to research those kind of statistics or investigate those kinds of issues, and Congress has forbidden them to do that. So it's against the law for the Center for Disease Control, that's what it is, to look into the effect of guns on the incidence of, I guess, homicides. So that's difficult. One thing I would note is there's certain regulations that most people agree on. Not that it would make it easy to enact them, but I was watching the news today, and President Biden has just issued an executive order creating a rule that what are called ghost guns must have serial numbers so they can be traced, the ownership can be traced. They didn't in the past. These are more or less, you buy the critical part, which typically didn't have a serial number, and then you built your own gun around that critical part. And it was a way for people that shouldn't have guns, that legally can't have guns, like felons, to make their own and then fly under the radar until, of course, they used the gun in a crime. So there are certain laws that could be passed, certain regulations that could be passed, that I think would receive wide support and wouldn't be very controversial. Another one I can think of, if you recall that that shooting, that mass shooting in Nevada, in Las Vegas, about 5 years ago, where the shooter was using something called a bump stock, which essentially turns a semi-automatic rifle into a machine gun. Those were quickly, a regulation was quickly passed forbidding the sale of those things during the Trump administration. So I'm sure there were folks out there that wanted their bump stocks, but there were way, way more that were interested in seeing them taken off the market. I hope that answers your question. I mean, this is a controversial area, and every attempt at regulation is going to be met with resistance.
What would make the legislators not want the CDC to analyze gun death data? I don't understand that.
Okay, here's why. The National Rifle Association believed that it would lead to, if people knew what the statistics were and if they were bad for gun ownership, it would lead to enough pressure on Congress to enact new legislation regulating guns. And they don't like that. And They made sure to make enough donations in strategic spots so that they could get their way with that. And of course, the president had to sign it. I can't remember when that legislation came into effect. But I was very surprised to learn a number of years ago when I first found out about it that there was such a law.
There's one question that wasn't asked directly, and that was about, gender neutral. How does that affect the ERA?
I don't think it does. I mean, if you're going to bring a lawsuit based on gender discrimination, you're going to have to say I was discriminated against on the basis of my gender. And if you're claiming that you're gender neutral, you just can't do that. I know that people say they're gender neutral, and God bless them. I'm glad that there's a group of us that don't see any difference between human beings, but I don't think it's going to have much of a legal effect. I could be wrong about that. I'm not an expert in the area of sex discrimination law, but I don't see how you'd be able to do it.
Are there other questions?
Now, this is Dorothy. I was just going to ask what authority the private property owners have with regard to gun restriction on their premises.
Unlimited. If you own property and you don't want guns on the property, you can forbid guns. I would note that Senator Ron Johnson has a no firearms allowed sign in his Oshkosh office. So, I think that's pretty non-controversial.
The rights of the individual overall, right?
Yeah, right, exactly.
I just have a comment. I don't know if people saw it today, but there was a shooting on the subway in New York City, and there was a press conference, and all of the power players were women. I had never seen that before. The governor, the deputy governor, the chief of police, the head of the fire department, were all women. And it's the first time in my life I've ever seen that on live TV. So it just.
Wow.
Yeah. Progress, right?
Is something. I don't know. But they can't handle it any worse.
Yeah.
I have a similar story. It was in the New York Times a week or so ago that Germany is now, for the first time since World War II, they are rearming. They're building up their military and their national security infrastructure, and the top 3 positions are all held by women.
Mm. Well, why not?
Exactly.
I can't think of a better way to prevent war than to put women in.
that question, is there anything, Chris asked it, is there anything that the league can do? Yeah. The league can do to promote the ERA's passage through Congress, and yes, there is. Get on the phone or on your email and notify your Congress people that you want that resolution passed. But it's the sort of thing where the pressure has to be kept on day in and day out. Legislators have a very short attention span, and if you don't keep it in front of them all the time, things tend to fall by the wayside.
Don, do you happen to know who the 6 states were that wanted to rescind their ratification of the ERA?
Not off the top of my head, but I can tell you where you can find out. There's an excellent discussion in Wikipedia of the ERA, and they list all 6 of the states that passed rescission legislation in there. Matter of fact, there's a wealth of information in that article. There was no way I could have covered all the information that they have in a presentation like this.
What I was curious about is if it had a geographical emphasis in
I
one
don't
part
think
of the
so.
country.
I don't think so. If I recall,
Okay.
one of them was Minnesota and one of them was Idaho.
Wow.
And, yeah, if I recall correctly, but.
Are there any more questions or comments? This is really wonderful, Don. We just can't appreciate your expertise more. This is a very intense topics, both of these, that are near and dear to all of our hearts in very many ways. And there's much more discussion to be had on these topics. But we really appreciate having your expertise to rely upon during these tough times. I did, yes, so thank you so much.
Well, it was my pleasure.
Thank you, Don.
That's great.
You're welcome.
Before everybody leaves, I forgot to make the announcement earlier that our next meeting is going to be our annual meeting, and all members should have gotten an invitation to make an RSVP. We need to have at least 25 people RSVP in order to have an in-person meeting. We are going to be running it as a hybrid meeting with both Zoom and in person, if at all possible. And we're hoping that to be able to gather together. Once again, we are keeping a close watch on the CDC recommendations in terms of safety and all of the other things, so that we are making smart decisions this way. But we're all anxious to get back together and look at each other eye to eye and have good conversations on democracy and our community and the elections and the things that are happening. Now, our annual meeting is open to all. You don't have to be a member. Of course, we want to encourage you to join and be a member. But if you did not receive an invitation and you would like to attend our annual meeting, please put that request in an email to information@lwvnow.org. And that's where you can communicate with the league, with our local league, anytime that you want. Are there any other announcements from the group?
Pam, I've had my hand raised. I guess you can't see it on your screen. I just have one more, a general question for Don.
Please.
If he's still on. Don, given your experience researching these two topics and your experience as a lawyer and your study of the law, are you at this point more inclined to expend a lot of energy on passing constitutional amendments of this sort, or should we chisel away at things with laws, individual laws? I don't want to use the word piecemeal. I guess I'd call it a little step at a time technique.
Well, here's the way I look at it. There is the long view and the immediate view. And I think you want to promote amendments, recognizing that it's going to take a long time. Like James Madison was long gone before the 27th Amendment was passed. And all it said was that Congress people should not be able to raise their own salaries. It would be, they vote on them and then they don't become effective until the next term. So it can take some time, but you have to take, you have to attempt the amendments because that was the original way it was intended for us to move forward on constitutional matters. And just because it takes a long time and it takes a lot of work, you still have to do it because conditions are constantly changing. And an 18th century document can't possibly address all of the things that go on in the modern world. On the other hand, it is good to push for immediate statutes. I don't know how everyone feels about the Electoral College, but I have detested it ever since the 1970s because it distorts everything. Back in the 70s, I can remember people would win by, several million popular votes, but in the Electoral College, they would have won 40 out of the 50 states. And my God, that was a landslide. So we don't have to consider what anybody else, anybody but our supporters think. And now we've had, two elections that were won by the winner of the Electoral College rather than the one that got the most votes. Well, you can amend the Constitution and take that out. Or there is a statute circulating among the states, and it's been passed by quite a number already. And what it says is it's an interstate compact. So the states that sign on to it agree to be bound by it. And the condition is when there are enough states with enough electoral votes to get to 270, which is what you need to win the Electoral College. When enough of them have signed on to it, they are going to distribute the electoral votes in each of those states to the person that wins the popular vote. And that would solve the problem. If you see it as a problem, some people don't, Did that answer your question, Dorothy?
Yes, it did. And it also anticipated another question that I was going to pose. What other issues, deficiencies in our Constitution do you think are ripe for an amendment? And the Electoral College is one. Are there any others, and particularly others that you think have a better chance than the ERA and gun control?
Better chance. No amendment has a good chance. I mean, there's been many amendments that have failed, and we've only had 27 in the whole history of our country. But I don't know. There's a lot of things I'd like to see changed. Some of them wouldn't be too popular. I guess I would like to see the Second Amendment reformed a little bit to make clear that gun ownership is subject to reasonable regulation. I think that would be a great help and save a lot of lives. And I'd like to see something requiring the abolition of gerrymandering. That's a very anti-democratic tactic that is currently legal. The Supreme Court has washed their hands of it. They said, well, not racial gerrymandering, but partisan gerrymandering. The courts will no longer take up cases concerning that. So I would like to see that resolved. And also the idea that every state, no matter how small it is, gets 2 senators. I'm sorry, but that's very anti-democratic there too. So what chance they have? Yeah, go ahead.
I mean, isn't that one of the main reasons why Puerto Rico is not a state and the District of Columbia are not a state, because that would give them 2 senators each.
It's also why Dakota Territory was divided into 2 when South Dakota and North Dakota were created. Yes. So.
Right. Well, there's no lack of purpose. There's no lack of work to do.
Right.
When it comes to defending our democracy and taking a sober interest in what is going on and our history, taking a serious look at it. We so appreciate you coming and presenting with us today and giving us so much to think about.
You're most welcome.
More conversations.